I'm a barrister. I practice as a barrister here in the UK, but I also practice as a barrister in Ghana. This is a new feature this evening on Omega Live TV, and it's called The Legal Hour. We're being sponsored today by Omega House Multimedia. You can contact me today to ask any questions relating to what I'm talking about on 07961 700 521. I'm here to answer any questions on the topic for today. Today's topic is the migrant and driving offences. So what do I mean by that? I'm talking about people who are in the United Kingdom with some sort of restriction on their permission to be here. So you could have a visitor visa, you could have an EEA settlement, you could also be here as a spouse of a British national or as someone who's settled here. What sort of issues should you be looking at in relation to your driving matters and any possible driving offences? Okay, so let's look at the driving offences first. What do we mean by these? We could be talking about speeding, talking about driving whilst over the prescribed limit, which in other words means drink driving. Could also be looking at careless driving or something as small as driving without a seatbelt. So who deals with these types of cases? We look at the types of institutions in this country that deal with these offences. We're looking at the police. We're also looking at the magistrates' court, or even the Crown Court, which is the serious case type. So let's deal first with speeding. I know a lot of people have issues with speeding offences, and this is essentially going over the limit of that road that you're driving on. So it could be a 20 mile, 30 mile, or even on the motorway at 70 miles an hour. And there are different ways in which people are caught speeding. They're caught speeding by a camera, fixed camera, which often is a yellow box fixed by the side of the road, or they could even be caught by a police officer who's standing by the side of the road and using a laser beam handheld camera. Regardless of how you're caught speeding, the question is what happens when you are caught speeding. The first thing that happens is that the police will send you a letter by post. When they send this letter to you, they will first ask you to say who was driving on that occasion. The letter is sent to the person who is the registered keeper of the vehicle. So when they write to you, you have 28 days. 28 days in which to let them know who was driving the vehicle on that occasion. Now, it could either be you could have lent your car to somebody, or, excuse me, it could be a member of your family or anybody else. So when you reply to the police, and bear in mind you have 28 days, depending on who was driving and their driving history will dictate what happens. The police could decide to simply send you a notice after you said, for example, you're the driver on that occasion, send you a notice and tell you to pay a fine and also to have endorsed on your license 3 penalty points. If you choose not to respond to the police, we go into a different category. We go into the police then sending you a reminder letter asking you to name the person on that occasion, but also with a warning that if you don't name the person who is driving, you may be prosecuted as the registered keeper of the vehicle. Now, as the registered keeper, if the police then tell you that you haven't supplied the information or you haven't supplied the correct information, they can then summons you through the magistrates' court to attend for a hearing. This can either be a physical attendance, or you can even attend, as it were, by replying to the court summons and saying you don't want to attend court, you would rather enter your mitigation or your circumstances by post. If you reply and you say, for example, I'm not guilty, I wasn't the person driving on that occasion, or I did reply to the police, they didn't receive the notice that I sent to them, you would have to go to the magistrate's court at some point to answer questions about what happened on the day in question. What I think it's important for you to note is that if you are found guilty or you plead guilty for failing to supply to the police the correct information at the time, when it goes to the magistrate's court, there are two things that will be imposed. First, there'll be a fine, and the fine will be greater than if you had, for example, responded to the police at an earlier stage. And you will have penalty points imposed, and those penalty points will be a minimum of 6. If I take you back a few steps from what I've been talking about, if you had, for example, replied to the police initially and told them that, yes, you were the driver and you admit it, the police can give you 3 penalty points and a fine. So you see, there is a lot of incentive to actually responding to the notice that's initially sent to you by the police. One thing I should point out is that regardless of the reply that you give to the police, if your speed is excessive, so for example, a 30-mile-an-hour zone, and you are doing double of that, 60 or even 70, the police are more likely to actually take the case to court. That's because the speed is so excessive that the magistrates could in fact impose a disqualification on you. So depending on how far over the limit you are will dictate how it is dealt with. But the advice that I would give is at first instance, you should let the police know who was driving on that occasion, and then matters can be dealt with from there. I hope that that part is clear to you. So let's start looking at a couple of other things that to do with driving. No insurance is an interesting one. That is dealt with either by the police or again by the magistrates, depending on how you deal with it when you're first notified that the police are aware that you had no insurance. The minimum number of points for driving with no insurance is 6 penalty points, as well as a fine that's also imposed on you. The fine is dictated by your income. Okay? So one of the reasons why a lot of people fall foul of the no insurance regulations is because their employment is not covered as part of their insurance. By this, I mean that, for example, you're driving on a road, you're stopped by the police. They ask you if you have valid insurance. You tell them you do. But then they ask you to see your insurance policy. Now, of course, you don't have it to hand. They may ask you who your insurance company are and make some inquiries. During that period, the police could ask you, where are you going? You tell them, I'm going to work. They ask you, where do you work? And you give them a location, a fixed location. And when they check your insurance policy, if you are not covered by your insurance to go to work, then it means that you're in breach of the insurance policy that you have. And technically, it means you have no insurance for the journey that you're making. A lot of insurance policies these days say social and to one place of work. Again, that means if you work in multiple places, if the police stop you, ask you where you're going, and you say again, I'm going to work, they may make further inquiries from you as to what you mean by going to work. Are you working in one place? Are you working in more than one place? And if they find that you are working in multiple places, you're only supposed to elect one location as being the place where you're going to work. So if, for example, you have a head office or headquarters where you work, and there are also satellite places where you work, it would be assumed that the headquarters would be the place that you would elect as being the place where your insurance would cover you, and certainly not to any other location. So be careful of that, because oftentimes innocent people are caught out. We've just got a call coming through, so let's just see who that is. Hello, caller? Yeah, hi. Yeah. Can I have your question? Sorry, your question, please? Okay. That caller seems to have gone. Maybe they'll call us back in a few minutes. Okay. So if I continue, it may be that some more of you have some questions as I go along in any event. Let's look at another set of offences. We are looking now at failing to stop or failing to report an accident. Now, failing to stop or report an accident isn't something that the police deal with directly. That would usually go to the magistrate's court. If you fail to notify the police of an accident. Now, reporting an accident, you have 24 hours to do so. So phone the police, make sure it's a recorded call, write to the local police station. You simply need to notify, but bear in mind you have 24 hours after the accident in which to do so. Thank you. It seems we've got our caller back. Let's just see who this is. Hello, caller.
Oh, sorry, the line cut off. Yeah, what I'm saying is, I just want to ask a question, please.
Yes, of course.
Yeah, I'm calling from Birmingham. What it is that if I'm driving, most of the time, I'm always in argument with my friends when I'm with them.
Yes.
They want to drive my car and I refuse.
Yes.
One, they're saying that they have their own insurance, but I've not seen it. Should I let them drive and they don't have insurance?
Okay.
What happens to me? And should the car be stopped? Did that mean that I will lose my car? Or would they have to pay the responsibility with the police?
Okay. Thank you for that question. It's a good question, actually. If you are the registered keeper, so it's your vehicle, you should already have a policy of insurance in place for the vehicle. It covers you and the car. You should also, if your friends wish to drive, they should also have their own policy of insurance unless they are covered under your insurance. If they're not already covered, i.e. you haven't registered them as being covered on your insurance, then you need to ensure that they have registration. They're registered for insurance. If they're not registered for insurance, don't let them drive your vehicle. Because if they're stopped driving your vehicle and you are not there, for example, the police can indeed seize your car. If you're in the car at the time, then the police can tell you, well, you drive the vehicle and don't let the other person drive. And that person will receive the no insurance summons or a penalty from the police. But if you give your car to somebody and you know that they don't have insurance, you need to be a little bit careful that you don't end up also in trouble with the police for giving somebody your car with knowing they don't have insurance. All you need to do, though, to be honest, is just tell the police, look, he told me he has insurance. Yes, I didn't check, but I took him at his word. And usually it only ends up with that person being in trouble, not you. Okay, I hope that answers your question, caller. Oh, I think he's gone. Well, hopefully that's answered his question. So keep them coming. If anyone else has any questions, do call me. The number again is 07961 700 521. And I'll be happy to answer any questions that you have. Okay, so we've dealt with, as I said, the no insurance part. So we were talking about failing to stop or report an accident. Those, as I said, are dealt with in the magistrate's court, but the outcomes of such cases are quite serious. So if you have had an accident, especially if somebody's injured, you should actually stop. But if, for example, you've hit a parked car, there's not really much point in you stopping, as long as you report it within 24 hours. But if you have an accident where somebody is then injured, then you should stop at location. Let's just take another call. Hello, caller. Hello, caller. Yes. How can I help you?
Yeah, I wanted to find out how much is the driving offence fine?
Okay.
If you're fined, how much do you have to pay?
If it's dealt with in the magistrates' court, the limit is usually up to £2,500. But it depends on the type of offence it is. There are a plethora of offences under the driving rules. But essentially, they look at your income. So they will take a percentage of your income and use that as a fine. So typically, the ones that I see in the magistrates' court for minor offences, so for example, the speeding, if you've gone 3-4 miles over the speed limit, then they'll typically impose fines of about £100, £200. And the more serious the offence, the more likely they are to impose a greater penalty against you. I see that our call has gone. I hope that answers your question. Again, as I said, keep them coming. Number 07961 700 521. We have another call, so I'll just take that call. Hello, caller. Yep, how can I help you? Hello, is anyone on the line? Is there anyone on the line? Okay, I think they've gone. No doubt they'll call back if they need some more help. Okay, so we're still dealing with failing to stop or report an accident. And as I said, this is quite a serious offence because, of course, especially if there's somebody injured, or if there are multiple injuries, or you've got past offences for driving offences, then those can be quite serious. And those are called what we call aggravating circumstances. So things that make it worse rather than better. The penalties imposed start at fines. As I said earlier to the earlier caller, it starts at a fine. You can go up to points, disqualification, and even a community order. Up to the most serious of the failing to report or stop is 26 weeks in prison. So it's very, very, very important, especially if you've got a checkered past with the police and driving, that as soon as you have an accident, you report it. It's much less expensive for you if you do that than insisting on hiding or not telling of the offence that's been committed by you. You never know. With the failing to report an accident, for example, if you've had an accident, you've hit a parked car, okay? You go to the police, you tell the police, I hit a parked car on such and such a street, such and such a time, and this is the license plate number of the other vehicle. The police are unlikely to go looking for that vehicle. They will actually wait for the other driver to come to them and say, oh, I've had an accident, somebody's hit my vehicle, I don't know who it was, etc. And then the police will then start tracing. But if they don't know, if nobody comes to them to make the complaint, in this day and age, the police are very unlikely to go looking for the person who you had an accident with, unless, of course, the accident's quite serious. If it's serious and people are injured, then they'll follow that up. But if it's just a minor fault, the police are likely to tell the other driver just to simply report it to their insurers. So next part that I'm going to look at are other offences. One that I see come up quite commonly is driving whilst under the influence of drugs or alcohol. Now, we'll deal with alcohol. This is dealt with again in the magistrates' court. Even if the police stop you by the roadside and you're, in their opinion, intoxicated, they then carry out a roadside test to measure the amount of alcohol in your breath. If you fail the roadside test, the police will then arrest you and take you to the police station immediately. Once at the police station, they will then use a more sophisticated test and test you 2 or 3 times to see what the strength of alcohol is in your breath. Now, often the question I'm asked is, well, how much do you need to drink in order to be over the limit? This rather depends on a lot. It depends on your body shape, your size, how used your body is to drinking, your metabolic rate as well. We've just got another caller. Let me just answer this and then we'll deal with the driving on drink. Yes, caller, how can I help you? Hello. Yeah. How can I help you? Hello, caller. Hello, caller. Are you there? Hello. Okay. Well, they seem to have gone. Let's continue where we left off. So the drinking. Okay. So how much do you need to drink to be over the limit? To be frank, my general advice to people is just don't drink and drive because it's always difficult. It depends on your metabolic rate. It depends on the strength of the alcohol you're drinking. It depends on how long the gap is between drinking and then actually driving. Not only is there drink driving, there's also being in charge of. So even if you're behind the wheel of the car, you put your keys in the ignition, you are in charge of the vehicle. Even for that, you can be stopped by the police. The police can come to your vehicle, knock on your window, ask you what you're doing, tell you to step out of the car, and breathalyze you. So you need to be quite careful on those things. Now, how much to drink? Anything such as 2 small glasses of wine would put you over the limit. And when I say small, small is usually 125 ml. 2 pints of regular beer or lager will take you over the limit. 2 shots of spirits will take you over the limit. Okay, so again, you've got to be really careful. I know people who buy, if you like, the bottles of beer. Those are usually 1.7 units of beer. Let's just answer this call. Hello, caller. Hello. Hello, caller. Your question, please. I can see someone's on the line, but for some reason we can't hear them. Let's see. Hello, caller. Would you like to state your question, please? No, again, they've gone. Okay. So it may surprise some of you, the limits that I've told you about, but those are they're only guidance to you. Some people can absorb more than others. Some people can absorb less than others. And if, of course, you've just had 2 shots of, I don't know, whiskey, and then you immediately get into your car and start driving, if you're stopped by the police, then you're likely to find yourself in trouble. What is the trouble that you could find yourself in? You could find yourself in significant trouble with a 12-month ban. Okay, I think the same caller's calling back. Let's try again. Hello, caller. Hello.
Hello?
Yeah, hello, caller. Hello?
Hello.
Yeah, I can hear
I
you.
can't hear very well. I'll ask some questions.
Please do.
So once something caught speeding,
Yeah.
how long does it take for a letter to come through from the police?
Oh, okay. Yeah, going back to the speeding question or issue that we were talking about earlier, and thank you for your question. If you're caught speeding, if the camera takes a photograph of you, the police have 14 days to send a notice to the registered keeper. If they don't send a letter within 14 days, it's not necessarily that you're off the hook, but it becomes a little bit easier to argue against the police once it's over that 14-day time scale. Let's say the police do send it within 14 days and you reply and you were doing 60 miles an hour in a 30-mile-an-hour zone. Once you've responded, they have 6 months to bring a prosecution against you. If they don't within the 6 months, they cannot revive that at a later date. So you can't have something hanging over your head indefinitely. If you fail to respond, of course, the police can then write to you again, as I said earlier, and effectively chase you for the person who was driving on that day. And if you don't respond again, the police can then take you to court on the basis that you failed to nominate or name the driver on a particular occasion. The caller's gone, but I hope that, caller, that's answered your question. So thank you for that. Okay, so again, going back to the driving, whilst you are intoxicated. I think I was just about to say that a 330ml bottle of beer, as the final example, is what's called 1.7 units. To be over the limit, you should be at two units or more. So a 330ml bottle of beer like San Miguel or whatever is 1.7 units. Okay, so you're quite close to the limit, but if you can nurse that bottle for the whole evening, then you shouldn't have any further problems. Okay, so then ban, automatic ban, if you're found guilty or you plead guilty, magistrate's court is 12 months. Okay, and that's the minimum again. They can go anything up to 36 months ban, and a financial penalty up to £2,500, and points on your license anything from 3 to 11 points. So the further you are over the limit, the more offences you've got as a drink driver previously, the more likely you are to get more points, higher penalty, and a larger or an increased period of ban. If you are a first-time offender, those 12 months can be reduced to 9 months. So when you go to the magistrate's court, and you will have to make a personal appearance, I'm afraid, you go to court, you plead guilty or you're found guilty, they then impose 12 months. You elect to do what's called a drink drive rehabilitation course. That will then take your driving ban period from 12 months down to 9 months, so a reduction of 25%. But you have to complete that course in order to get the reduction. If you don't complete the course within the time that they give you or they impose, then you'll have to do the whole 12 months by ban. Drink driving offences can carry imprisonment. It's rare if it's your first offence, but it is possible. So please be aware of the penalties. If you have a second drink drive offence within 10 years, so you've had one drive offence in 2015, and then 2020, another drink drive offence, you will then be banned for a minimum of 3 years, because it's almost as though they gave you 12 months on the first occasion. You then within 10 years get a second drink drive offence, you get a ban, automatic minimum of 3 years, plus a disqualification. Well, that's a disqualification plus possible imprisonment. Usually, I have to say, if they're going to impose imprisonment, it's usually on the third drink drive ban, but there's nothing to stop them from imposing that on even the first or second occasion. It just depends on how far over the limit you are. Also be aware that the magistrates can not only ban you, but after your ban period is finished, tell you to retake your driving test. You'd also have to tell your insurance company, which means your insurance premiums will go up inevitably. Okay? So again, that's something else to be aware of. There's something else I should tell you about, which is called totting. Amongst us lawyers, and we know this is totting. Totting is when a person receives 12 points on their driving license within 3 years. If you receive, for example, let's say a speeding ticket and you got 3 penalty points, then you do get a no insurance a year later, so you get 6 penalty points. And then you get another speeding offence 6 months later, and then you get 3 penalty points. That equals 12. At that point, the magistrate will ban you from driving. Okay. Now, there is no minimum in terms of how long that ban period is for, but the magistrates have a discretion as to how long to ban you from driving. So again, you need to be careful. The ban that comes as a result of penalty points includes people who don't have a license. So let's say you're driving without a license and you're given 6 points for doing so, and then you pass your driving test. Because you've got 6 points, you are technically a new driver. So because you're a new driver, you're automatically banned, because all new drivers cannot get more than 6 points on their license. So let's say, I don't know, you got those 6 points, and then 2 years after being a new driver, you get another 6 points for no insurance. So you're now an established driver. Again, that means you get 12 penalty points and you'll be banned from driving. I think somebody else is trying to call, but let's wait and see if they'll call back. So yeah, so if you're a new driver, be careful, certainly, because any 6 points within 2 years, you'll be banned. And that means that you will have to retake your test again. So you passed 6 months ago, get 6 penalty points, you then have to retake your test. And that would be a shame given how much people have to spend these days on learning to drive. There are some offences for which you don't get points on your license, you get fines. Example, failing to wear a seatbelt. And if you are the driver of the vehicle, your passenger is an adult, it is the adult who is in trouble. If the passenger is a child, then the fine is imposed on the driver. Using a handheld mobile phone whilst driving, again, those are penalty points as well as a fine these days, because it seems to me that people weren't listening. So those have increased. So I think in terms of looking at driving offences, we've sort of gone through the main ones that I know that often come up. So I hope you've all found that useful. I'm just going to deal with the next part of that, which is what I talked about at the beginning of the programme, which is what happens to the migrant when there are these offences held against you. So you have, for all intents and purposes, now a criminal conviction. First of all, it's a pity to have a criminal conviction, especially if you have some sort of temporary stay in the United Kingdom, because it can impact on either you seeking indefinite leave to remain in the UK, or even it can impact on a naturalisation application, which is an application towards British citizenship. Okay, so let's look at the naturalisation application. So you've been here for X number of years, you're now entitled to apply for British citizenship. So, and that's through what, as I said, is naturalisation. There are certain criminal offences, or rather sentences that are imposed, for which you have to wait for a certain period of time before you can successfully obtain non-custodial or trafficking, driving, non-prison because of them. You have to wait 3 years after the conviction in order to then apply successfully for naturalisation. So if, for example, your driving offence was in 2019, you would have to wait 3 years before you can then successfully apply for naturalisation. If you applied, for example, this year in 2020, they would refuse you on the basis that you have a non-custodial sentence and a period of 3 years has not passed. If you find yourself in the unfortunate position of going to prison because of your driving offences, or offence even, any prison sentence that is less than 12 months, you cannot successfully naturalise as a British citizen until 10 years has passed since the end of your sentence. So there's a slight change here. If you went to prison in March 2019 and you went for, let's say, 11 months, so that means it finishes in February 2020, okay? So that's an 11-month prison sentence. You would have to wait until 2030 before you could apply to naturalise as a British citizen. So I hope that's clear. Any sentence less than 12 months, you have to wait 10 years after the end of the sentence. The longer the sentence, the steeper the period that you have to wait. So a prison sentence of, or custodial sentence, it's the same thing, of between 12 months and under 4 years. So let's say 3 years 11 months and 10 days, for example, you would have to wait for 15 years since the end of the sentence before you can successfully apply to naturalize as a British citizen. When I say the end of the sentence as well, that means the prison sentence. Oftentimes people go to prison for, they're given a prison sentence of 12 months, but then they only have to serve 6 months. So they do half or a third if you're on early release. You still have to wait until the end of the 12 months. So it's the whole of the period that's imposed before you start counting your 10 years or your 15 years. If you have received a prison sentence of 4 years or more, it is highly unlikely that you can naturalize as a British citizen. And the guidance to the Home Office is that they will normally refuse such applications. Now that deals with those applying to naturalise. You've also got those who aren't applying to naturalise, but either are applying for entry clearance, that means to come to the United Kingdom, or those who are applying for some sort of further leave to remain or even indefinite leave to remain. The period by which you have to wait before you can apply for your further or indefinite leave to remain are similar to those under naturalisation, but slightly shorter periods of time. So the only two that are different are where you have received a non-custodial sentence. So remember I talked about the penalty points, etc. So if you've received such a sentence within the last 24 months, which is 2 years, then you would be unlikely to be successful in an application for further leave to remain or indefinite leave. So that's 2 years, whereas under naturalisation, if you remember, under naturalisation, I said it's 3 years, okay? So it's slightly less. And then if you've been convicted of a sentence, of an offence, for which you were given a sentence of less than 12 months, 7 years needs to have passed. Whereas if you remember under naturalisation, I said 10 years needed to have passed. So there are some differences. Then you need to be aware of those. And if you're not clear on any of those, then of course you can seek legal advice, and you should seek legal advice in order to get further guidance on whether you should be making applications to the Home Office or to the Passport Office, or whether you need to in fact wait before applying. Because most of these types of applications that people make to the Home Office or Passport Office are now costing in the thousands of pounds. You don't get a refund, they don't give you any money back. So if you are going to make such applications, make sure that your documents are in good working order and that you have everything at hand. I often advise clients that if they're not sure about criminal offences, which ones they've had or which ones they haven't had, the best thing to do is you can make an application to the police for what's called a subject access request, which is ask the police to send you all the information that they have on you in relation to any criminal offences. It's free of charge, and they send that normally within the month. So you know whether there's anything imposed on you that you weren't clear on. The reason why you should be clear on these is because on the application forms to the Home Office or to Passport Office, they often ask questions such as, what was the offence? When was it imposed? What was the penalty? How long, for example, did you serve in prison? How long was the prison sentence? So if you're not quite sure, my advice is refer back to the police and they'll give you the information that you need. If you don't do that and you make mistakes on the form, or if you fail to give to the Home Office or the Passport Office the relevant information about criminal convictions, the penalty for that, or the outcome, is that you could be refused any future applications you make for the next 10 years. So if, for example, you're entitled to naturalise as a British citizen this year, and you had a driving offence for which you received penalty points and a fine from the Magistrates Court in 2018, in your naturalisation application, they would expect you to declare it, much apart from the fact that it would be refused, I would say, automatically, because only 2 years has passed. even if the relevant period had passed, what would then happen to you if you failed to declare it is they would say, essentially in the refusal letter, thank you very much for your application, it has been refused because you failed to tell us about a criminal conviction which you have. Now, sadly, that happens more often than not. You don't want to be caught foul of that or to find that your application is automatically refused because you failed to disclose information which you could easily have disclosed. As I said, the easy way to get around it before you spend almost £2,000 on these types of applications is to make sure that you do not have any convictions. Simply write to the police. The police aren't going to come and arrest you. They're not going to come and remind you of penalties that you've failed to pay or fine that you failed to pay in the past. They're a separate unit that simply look at what convictions you have held against you. Also be aware on some of these application forms from the Home Office that they ask questions such as, do you have an impending prosecution? So even if the police have written to you and told you that they're thinking of taking you to court for a particular offence they think you've committed, on some of the application forms from the Home Office, they ask, do you have any current pending prosecutions? So something that may be coming up soon. I would advise all clients simply declare. It's much, much easier because it may end up that nothing happens from the criminal matter, or you may want to wait until the end of the criminal matter before you then make the relevant application to the Home Office. Okay, we've got one other caller who wanted to call but has gone off the line. So we'll wait and see whether they call back. But I wanted really to start concluding in terms of the way in which migrants or just anybody should be looking at driving offences. There are, as I'd said, the least significant driving offences, and then there are more significant driving offences. So depending on what offence you have committed will then dictate to you as the migrant as to whether you need to declare these to the police or not. I hope you have found this programme interesting and helpful. I've given you a lot of information. The advantage of modern media is you can go back and watch this again and again if you're not sure about some of the advice I've given. Of course, I strongly recommend that when you're making your application, you seek your own independent legal advice, because my advice is relevant only as at today's date. If they change the law tomorrow, then you've got to be careful as to what information you've taken away from this, but also speak to your own lawyer or your own representative to find out really what happens hereafter. Okay, so I'm going to wrap up now the programme this evening. As I said, my name is Linda Appiah. I've been your host. I invite any of you that if there are programs or themes you want me to talk about in the future, if there are any topics that you find interesting, they don't have to do with immigration, or they could be, they don't have to do with driving offences, it could be any area of the law, then please do message me, inbox us at Omega on Facebook, or you can message me on the number that's been provided, and then we'll look to see what are the common issues that people have, and we'll deal with those on the next program or any subsequent programs. Okay, so as I said, my name's Linda Appiah. I've been your host for this evening, and I hope to see you again soon.